Good afternoon, dzień dobry, good morning, good evening. Here is Małgosia Grys, the VP of Strong Women in IT from my Warsaw home studio. And I welcome everyone on our webinar connected with women in the leadership positions, the European Union Directive, which is coming in place this year and the further years, having an impact on the women on boards and women in the supervisory board roles. I have to tell you that every time is a great pleasure for me or Anita Kijanka, our CEO, to host these events. Today, however, is a super special moment because for the first time in our history, we are giving the floor fully to one of our partners and the legal partner of Strong Women in IT, GESSEL Attorneys at Law. Welcoming you, I really wish to state that GESSEL was founded 30 years ago by the top professional, the woman, who brought the legal perspective into the business. I've been working with GESSEL for many years and looking at their history, how they do, what they do, their legal knowledge and the way how they advise. I am even more honored to welcome two extraordinary legal attorneys today with us. And let them conduct the webinar to help you all, whether you are a woman or a man, to get acquainted with the knowledge, which is really important in terms of awareness, in terms of execution, and in terms of bringing equality to life and business. With no further ado, it's my honor and pleasure to welcome Anna Ziewalic, attorney at law, and Maria Dudzińska, attorney at law of GESSEL in Poland, with the inspiring story within Strong Women in IT. Ladies, my pleasure, and the floor is yours.
Hello, everybody. My name is Maria Dudzińska. And together with Anna Ziewalic, we are going to tell you something more about CSRD. I am an attorney at law, as Małgosia said, and I cooperate with GESSEL, a law firm, for over 10 years. I'm an expert in dispute resolution and I advise Polish and foreign companies how to manage the conflicts and disputes and how to avoid them.
My name is Anna Ziewalic, and I am an advocate and a managing associate at GESSEL. For over 10 years, I have been assisting entrepreneurs in navigating market changes and legal developments. I too specialize in dispute resolution. I provide clients with advice on how to avoid a dispute, and if a dispute has already arisen, I represent them in court or in arbitration. Let's start the presentation. Welcome to our first webinar in the series Legal Insights for Modern Leaders by GESSEL, in which we discuss legal issues every modern leader should know. Today, our focus is on the Corporate Sustainability Reporting Directive, in short, CSRD, and its implications for women in business. We will explore how this legal act shapes the situation of women in the corporate world and how it may affect you as an individual associated with a company, whether you are a member of the board, an employee, or a customer. And here's how we're gonna do it. We're going to discuss the following 3 topics. First, does your company have an obligation to meet the requirements stemming from CSRD? Second, how will CSRD and other legal regulations encourage gender diversity within your company? And third, how will these regulations promote equality, in particular equal pay, within your company?
But firstly, let us to say something more about this webinar, because we were more than happy when Małgosia asked us to support strong women in IT. And this is our first webinar, and the idea is to share with you with some legal insights and maybe to help you with some legal problems you face. At the very beginning, we wanted to choose a different topic for our webinar. But during the discussion about CSRD, it turned out that there are many questions among the management bodies regarding those provisions. And we decided to take a look once again to those things and to things that will change.
Exactly. So before we discuss how CSRD addresses the role of women in business, I would like to tell you a little bit about CSRD in general. As I have previously mentioned, CSRD stands for the Corporate Sustainability Reporting Directive, which took effect in January 2023. CSRD mandates certain companies to prepare and submit non-financial reports focusing on three key areas, collectively known as ESG. As you probably already know, the E in ESG stands for environmental issues, the S for social issues, and the G for broadly understood corporate governance. The primary objective of CSRD is to furnish stakeholders of a given company with information that enables them to evaluate the company from a sustainability perspective. And by now, all of you probably have heard about the environmental aspect of reporting, such as, for example, carbon footprint. But here's something interesting. According to the Berenberg 2021 ESG survey, nearly 50% of investors consider the social aspect of reporting the most important when making decisions, while only 35% prioritize the environmental aspect. So I think it's high time for us to expand our thinking beyond just the carbon footprint. And this is what we're going to do today. I also want to mention that every member state of the European Union is obligated to implement CSRD into national law by July 2024. And in Poland, the government is already drafting an amendment to the Accounting Act, in Polish Ustawa o Rachunkowości, and other relevant legislation to implement CSRD. So recently, CSRD is something of a hot topic appearing everywhere in the media. And you may rightly ask yourselves a question, is it really a revolution in ESG reporting? Personally, I think it is. It is true that CSRD is not the first legal act regulating these issues. Before CSRD, there was NFRD. In other words, the Non-Financial Reporting Directive. It entered into force in 2017 and is still applicable. However, CSRD can still be considered revolutionary for three main reasons. First, CSRD has a much broader scope of application than NFRD, meaning that it is applicable to more companies. Second, for the first time, CSRD imposes unified reporting standards, and these are much more detailed and ambitious than the ones applicable under NFRD. Third, CSRD establishes the so-called external attestation of the reported information by certified auditors, which is also new. As mentioned before, CSRD has a much broader scope than NFRD. NFRD only applies to large public interest entities, such as, for example, banks, listed companies, or insurance companies, and all of them have to have over 500 employees. NFRD only covers over 10,000 companies. By contrast, CSRD is applicable to 4 different groups of companies, and it is estimated that it will cover over 50,000 companies, so 5 times more than NFRD. At this point, you are probably all wondering how these regulations apply to your company and to what extent. I assume you would like to know whether your company will be obligated to report under CSRD, and if yes, when. You can easily find answers to these questions by analyzing the presented diagram. I would like to ask you a couple of questions. Question 1. Does your company already fall within the scope of NFRD? If the answer is yes, it needs to file the first report in 2025 for the year 2024. Question 2. Is your company the so-called large company or a parent company of a large group? And you can easily check whether your company qualifies as a large company by analyzing the data below related to the number of employees, net turnover, and total assets. If the answer is yes, your company needs to file the first report in 2026 for 2025. Question 3. Is your company the so-called SME, meaning small or medium-sized enterprise? And is it at the same time listed on a regulated market in the European Union? And again, you can check whether your company qualifies as the so-called SME by analyzing the data before you. If the answer is yes, your company needs to file the first report under CSRD in 2027 for the year 2026. However, it is worth noting that every SME may simply opt out of reporting until the year 2029. If it decides to do it, it only has to publish this information in its annual report, together with a short explanation. Last but not least, question 4. Is your company from outside the European Union, has a net turnover of more than 150 million euros, and has a branch or a subsidiary in the EU? Again, if the answer is yes, your company needs to file the first report under CSRD in 2029 for the year 2028. I hope that at this stage you have discovered whether your company is covered by CSRD. And if not, you can always go back to these requirements later on and analyze them. Or, of course, you can reach out to us. I will now pass the voice to my colleague Maria, who will explain further reasons that make CSRD a truly revolutionary act in the world of ESG reporting.
So, regarding the reporting standards, as in comparison with NFRD, CSRD established the new standards of reporting, and moreover, such standards will be standardized. I mean that they that will be the same for all reporting entities. It's important because previously there were difficulties with, for example, comparing companies. And the reports should be done in accordance with so-called European Sustainability Reporting Standards, so ESRS, published in December 2023 by European Commission. And the CSRD report will be included in the management report, which is generally included in the annual report. It means that the members of the management board will be responsible for the content of the report, so as they are responsible for the annual report. It also means that it will be publicly available. What's interesting, the EU authorities plan to improve the search system regarding reports by preparing a special database called European Single Access Point. And the presentation shows an illustrative report structure. It covers all reporting areas. However, some areas will be subject to reporting only if so-called materiality threshold is met. And the sustainability reporting will be based on the principle of so-called double materiality or dual materiality. And the companies are expected to disclose material information covering two areas. First, impact materiality, known as the inside-out approach, as it relates to the impact that the company has on sustainability matter, for example, on people or the environment. And second, the financial materiality, known as the outside-in approach, as it relates to the effects of sustainability matters on the company. And what's also important, there will be third-party assurance. What does it mean? Companies will be verified by accredited auditors, and the attestation standards should be adopted by the European Commission by October 2026. And these standards will require member states to implement them, and the auditors will prepare relevant attestation reports based on them.
Although CSRD imposes reporting obligations on companies in all the ESG areas mentioned by Maria, today we would like to talk about how it can affect women's position in business. And two most important issues addressed by CSRD in this regard are first, gender diversity, and second, equal pay. Regarding gender diversity, first, I would like to stress out the importance of regulations addressing gender diversity. Many studies show that diversity simply pays off. If the board of the company is composed of males and females, ideally in 50-50 proportion, it impacts positively both the company's innovativeness and profitability. Studies also show that the share of women on the board must be at least 30%. Otherwise, they have no real influence on the decision-making process. However, if one looks at the statistical data, it is clear that women are underrepresented in the boards of companies, both in Poland and in Europe. As you can see, according to the Eurostat, in Poland, as at December 2022, women constituted only 24% of the management boards of public companies. Of both the management boards and the supervisory boards. Thus, the result of Poland was below the European Union average, which is 32%. This also places us somewhere in the middle of the table between France with 45% participation and Bulgaria with its 14%. Furthermore, if we take a look at the percentage of women constituting the members of the management boards of the Polish companies listed on GPW, the situation unfortunately looks even worse. Women in 2022 constituted only 10%. So the question remains, how can we increase women's position in top management positions? And I have to tell you, CSRD certainly is the step in the right direction. CSRD alone establishes several rules concerning gender diversity, and they are contained in two particular standards. The first standard under the CSRD is called Own Workforce, and it concerns the company's employees. And the second standard is called Business Conduct, and this refers to the corporate governance of the companies. CSRD contains two basic but important requirements. First, companies are obligated to report the percentage of women, both in top management positions and in the overall workforce. So this information will be publicly available in the future. And second, companies are obligated to implement policies aimed at achieving gender diversity. So these are already important regulations, but CSRD is further supplemented by the provisions of the so-called Women on Boards Directive. Let me present a couple of important facts about this directive. It has been ratified in December 2022, nearly 10 years after it has been presented to the European Commission, because it was so controversial and many countries opposed its adoption. Why was it so controversial, you may ask? Because it seeks to promote gender diversity by introducing the so-called gender representation quotas, in Polish, parytety, for the boards of listed companies. It is worth noting that this directive has a much narrower scope than CSRD, as it only applies to large stock-listed companies operating in the European Union. Member states are required to implement this directive by December 2024, and all the companies covered by the directive should comply by June 2026. Moving on to the content of the directive. The question remains, did it rightly stir up so much controversy? As I have mentioned before, the directive establishes gender representation quotas. Every company covered by the directive should ensure that at least 40% of all non-executive directors are women, meaning supervisory boards, or at least 33% of all the directors are women. So this means both management boards and supervisory boards. However, it is important to understand that these quotas are not absolutely mandatory. If a company does not meet the target, it is not to be penalized in any way. It only has to set quantitative objectives to be fulfilled in the future and make sure that it has an objective selection process for the candidates. So to me, this requirement doesn't seem so stringent after all. What it means, an objective selection process? It means that when two candidates of different sex apply for the same position, a company should simply choose a candidate that is better qualified for the job. Only if two candidates of different sex apply for the same position and they are not equally qualified, the company should then choose a woman or a person from the underrepresented sex. However, even in this case, a man may also be chosen if there are important reasons supporting this solution, such as, for example, fulfilling other diversity policies related to his age, race, disability, and so on. And finally, I have to mention that for companies that do not comply with these requirements, member states are obligated to set effective penalties. That means fines, but also annulment of appointments to the governing bodies, which were made contrary to these rules. So, what should your company do in connection with the adoption of these regulations? First, you have to determine whether you are obligated to report under CSRD, which I hope we have already helped you to do. Second, please bear in mind that under CSRD, reporting on gender diversity is always mandatory, which means that you do not have to conduct this materiality analysis that Maria has talked about before. Third, you have to collect relevant data regarding gender diversity, both in top management and in the overall workforce, so that you can report them later on. Next, you should implement a policy regarding gender diversity, which may, of course, be an element of a broader company policy. Last but not least, especially if your company is covered by the Women on Boards Directive, you should carefully organize your recruitment process and document your recruitment decisions so that you may justify them later on. And now, once again, I give the floor to Maria.
Thank you, Anya. And now let's take a look at statistics again as it comes to equal pay. And according to Eurostat data, there are differences between men and women remuneration in the EU countries. It's from 4% up to even 20%. So there is a problem, and it is noticed by the EU authorities. The unadjusted gender pay gap is defined as the difference between the average gross hourly earnings of men and women expressed as the percentage of the average gross hourly earnings of men. It is calculated for enterprises with 10 or more employees. What's more, we have to remember that one of the fundamental principles established by Article 157 of the Treaty on the Functioning of the European Union is that equal pay for equal work or work of equal value. So this is why the EU decided to step up the pace and include some regulations regarding the CSRD. There are some requirements for companies, such reporting the percentage of women in top management positions and in the entire staff, implementing policies aimed at gender diversity. Those stem from, as I said before, ESRS S1 called Own Workforce and ESRS G1 called Business Conduct. So, as far as CSRD requires the companies to report on standards regarding gender equality and equal pay, including gender gap, it is supplemented in other EU Act, EU Pay Transparency Directive, adopted in April 2023. All the EU member states have to implement it until 2026. And what is the subject of it? It requires employers to compare salaries in terms of the work performed and job groups. And the key elements of the Pay Transparency Directive include the following. First, companies must provide information about the pay level of the job listings before job interviews. Second, employees must be allowed to access criteria used to define salary and pay raises. They may also request information on individual or average pay levels categorized by gender for workers doing the same work. 3, if there is an unjustified gender pay gap or 5% or more, employers are required to carry out a so-called joint pay assessments, JPA, in cooperation with workers' representatives. So JPA will be, let's say, the kind of report showing the salary grid in the organization. And finally, 4, if pay discrimination is proven, employees are entitled to compensation, including full recovery of back pay and bonuses. First reports under EU Pay Transparency Act are due by June 2026. And so what we should do, how to be prepared for it. Firstly, the companies should have their own reasonable and transparent salary grid and policy. Maybe it's time to overview the policy that your company adopts, or if there is no such a policy, to prepare a reliable one. It will be helpful even to conclude whether the entity has a pay gap or not, and if it is about to exceed the level of 5%. And surely we have to wait for the certain legislation and provisions that member states are obliged to implement. So the key takeaways are, firstly, to have remuneration policy, to have transparent rules, and also to watch what the authorities of the member states are going to do, how they will adopt it. So maybe if you have some questions, please.
Or maybe it is the time to make present to you a little bit of a summary, which I would now like to offer before we proceed to the questions. So today we have discussed just one small aspect of CSRD, which is how it influences the position of women in your company. And at this point, when we are about to finish this discussion, I invite you to take a moment to reflect. Is your organization prepared to navigate the intricacies of CSRD compliance? Do you understand the implications of these requirements on your business? And finally, have you taken the necessary steps to ensure that you're on track to meet these obligations in a timely manner? The answer to all these questions, I believe, lie within your grasps. So I urge you to seize this opportunity to chart a course towards CSRD compliance. We can navigate these regulatory waters with confidence and ensure that your company not only meets the obligations stemming from this directive, but also emerges as a leader in sustainable and responsible business practices. I think this should be our goal.
So thank you for your attention. There is no time to tell everything about the CSRD topic, but hopefully it was something for you to start thinking about it and to think what your companies can do to be prepared and to have better, for example, policies and just to be prepared for those changes that we are going to face. As we said before, this is the first webinar from our cycle, Legal Insights for Modern Leaders by GESSEL. And we invite you to the next one, and the details will be available soon. And if you have any questions, you can see our emails. Please don't hesitate to contact us. And of course, you can do it via LinkedIn. And thank you for your attention, and see you soon.
Thank you also from my side.